Good evening, everyone. Well, it's evening my time anyway. We are due to receive motions from Blake Lively and various non-parties in regards to continued sealing of various exhibits that were attached to, I think, mainly the motion for summary judgment, but also for judgment on the pleadings and some of the sanctions. The first one we have is a 2-page letter motion from Isabela Ferrer's attorney. So we're just going to quickly go through that. Dear Judge Lyman, we write on behalf of non-party Isabella Farah, pursuant to Section 4B of Attachment A to your Honour's individual rules, to respectfully request that the Court maintain the sealing of Exhibit 75 to the declaration of Alexandra Shapiro in support of the Wayfarer Party's motion for summary judgment, Exhibit 10 to the declaration of Michael Gottlieb in support of Blake Lively's opposition to the Wayfarer Party's motion for summary judgment, and Exhibit 124 to the Gottlieb declaration. These exhibits consist of or disclose excerpts from Ms. Farah's deposition testimony containing highly sensitive confidential testimony regarding the filming of intimate scenes and discussion of another non-party religious affiliation. The testimony was designated confidential during the deposition pursuant to the operative protective orders, and good cause exists for the sealing to remain in place. Ms. Farah's request is consistent with the Court's November 26, 2025 order. In its recent memorandum and order, the Court directed parties and non-parties to explain how any proposed sealing related to the Wayfarer Party summary judgment filings is consistent with the Court's framework. The sealing Ms. Farah seeks falls squarely within the categories of information the Court identified as appropriate for protection even at the summary judgment stage, where the presumption of public access is strongest. As the Second Circuit and this Court have recognised, the privacy interests of non-parties should weigh heavily in a court's sealing analysis. Indeed, such non-party information falls within a venerable common law exception to the presumption of access, particularly where, as here, disclosure would reveal information traditionally considered private, including sensitive personal matters which are not central to the litigation and which have no public ramifications. The portions of testimony at issue here contain sensitive details regarding the filming of intimate sexual scenes and the religious affiliation of another non-party who is not involved in this litigation. The Court expressly recognised that the protection of such significant and substantial privacy interests as a higher value that may overcome even a strong presumption of access. Further, the Court has acknowledged the exceptional level of public and media attention surrounding the case. As a non-party who did not voluntarily choose to become involved in this litigation, Ms. Farah is particularly vulnerable to harassment and misuse of these sensitive excerpts, including widespread disclosures in the press and on social media. Such misuse carries an additional risk of professional harm to Ms. Farah, who is a working actress. The fact that, this trial is public, and the fact that she is a working actress does not make her particularly more vulnerable than any other non-party who's going to be filing these motions. But also, that does not override the public right of access, because all trials are public. Public circulation and potential distortion of intimate, highly personal testimony could negatively affect her opportunities within an industry that is uniquely sensitive to public perception. These risks fall squarely within the harms the Court recognised in its memorandum and order, and they outweigh any minimal public interest in disclosure. Minimal. It's not minimal public interest in disclosure, though. The public interest in disclosure is quite significant. I will also say as well that, I mean, I don't know much about the religious affiliations side of the deposition testimony, but the testimony around the filming of the intimate scenes is that is specifically in Blake Lively's complaints. I don't know why she put them in the complaints, because she cannot make a complaint on behalf of someone else. But she raised them in every complaint. She raised this complaint specifically about the young actress. And, if you want to talk about distortion here and how vulnerable she is to her testimony being distorted, Blake Lively quite literally portrayed, the filming of her scenes, kind of misled the public and suggested that because she was the young Lily, that, she worded it in a way that people thought that the actress was underage when she wasn't. So I don't know. I don't see why that would carry any weight, personally. Okay. The requested redactions are narrowly tailored so as not to impede public understanding of the parties' arguments and the court's adjudication thereof. The sealing Ms. Ferrer request is limited solely to the specific portions of the deposition experts that reveal sensitive information about Ms. Ferrer's filming of intimate scenes or the religious affiliation of another non-party. No broader sealing is requested. Sealing is necessary to, at a minimum, protect the following excerpts from Ms. Ferrer's deposition testimony. And then they list, the deposition pages, basically, in Exhibit 75, Exhibit 10, and Exhibit 124, which also includes a footnote as well, the final one. This tailoring is fully consistent with the court's direction that continued sealing must be justified by specific on-the-record findings and restricted to information that qualifies under the court's framework. Maintaining sealing of these limited excerpts of sensitive testimony will not impede the public's ability to understand the motion for summary judgment, the opposition thereto, or the court's decision. The motion papers themselves remain publicly available with only narrow redactions, and the small portions of testimony at issue are not necessary for the public to grasp the substance of the arguments or the court's analysis, consistent with the court's recognition that material having no bearing on the judicial function may be sealed, notwithstanding the strong presumption of access. In contrast, unsealing these intimate and highly personal excerpts would expose Ms. Ferrer to a significant risk of harassment and professional harm, a disproportionate consequence where the public's understanding of the issues would remain entirely unimpaired. When weighed, the balance here tips strongly in favor of sealing. I understand the concern for significant risk of harassment and professional harm, but I would say that there was a much greater risk of that when she, sort of about turned from her, adoring text messages or full of praise, telling just about only how he, provided such a safe set, etc., to ignoring his subpoena and, basically backing up Blake Lively. Yeah, this is an interesting filing to start with. I mean, Judge Lyman was very clear. It was like, well, say I'm famous is not an acceptable reason for sealing. And what she's basically saying here is, well, I'm a vulnerable actress. You're going to risk my harm and my reputational harm. I don't see what, because she's just talking about the filming of intimate scenes. Now, if unsealing this actually proves that what Blake Lively said was a lie about her intimate scenes, and she is not, kind of and she's kind of going along with that, then I could see the reputational harm. But again, that's she is the author of her own misfortune in that scenario. But all it is deposition about what happened during the filming of like a sex scene as an actress. There is nothing. I can't see any reason why that revealing that to the public would affect her professionally. So yeah, okay. So that's the first one down. We'll see what else we get. Also, my my little card, my thumbnail for this, I couldn't help but notice this, right? So I went looking for a picture of Isabella Farah, stumbled across one. I thought, great, that's her hand in hand with Blake Lively. And then I looked at what I can't even get her name out today because she's just annoying me already. Then I looked at what Blake Lively was actually wearing, and it basically looks like lingerie from Ann Summers. Ann Summers is a British sex shop, for anyone who doesn't know. And it took me back to the all her testimony about how she wanted to keep her onesie on to cover up her lace bra, but she's literally going out and about on the town in not much more than a lace bra. So that's my thinking behind that thumbnail. Anyway, all right, guys. I'm gonna leave it here, and we'll see what else comes down.